Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we are back in Calloway County with workers' compensation attorney Jeff Roberts. Jeff, how are you?
I'm doing good, Jim. How are you?
Buddy, I'm doing well. It's always good to be down in Murray. Today's a little bit of a snowy day, so I'm glad to get down here and chat with you for a bit.
Yes.
Today's going to be a different type of topic. It's workers' comp related, but if you're injured on the job, but you think it might have actually been your fault, and the question is, hey, in that situation, do I actually have a claim? So I think this is probably not all that uncommon. But there's a question about, again, if I caused my own injury or had a part in it, can I still get workers' compensation benefits?
Yes, that's a question actually that I have been asked by potential clients in the past and clients in the past when they feel that the injury was from their own making, so to speak. And frankly, it kind of depends on the situation. It's not just a simple yes or no answer to that question. So if the accident is or the injury is caused by you doing something, not using proper body mechanics or lifting techniques when you're lifting a heavy box, and that causes you to rupture a disc in your back, that really is not going to affect your entitlement to workers' compensation benefits at all from that standpoint. So just not using proper body mechanics in doing something is not going to cause you to lose workers' compensation benefits, not even going to cause a reduction in workers' compensation. And there's reasons for that. Basically, the entire workers' compensation system, which has been around in Kentucky for over a century now, was set up not only in Kentucky but in other states as well. The process was set up not to take into account negligence at all. It's not a fault-based system. At least my understanding of it is it kind of come about as part of the Industrial Revolution when you had employees who were getting hurt on the job through no fault of anyone, lifting a heavy item and rupturing a disc in their back, for instance, being a reason for that. And back then, before workers' comp was around, to recover any kind of compensation from the employer, you had to establish negligence. So you had people who were getting injured on the job who weren't getting their medical bills paid, who weren't getting any lost wage benefit, and if they were totally disabled or permanently injured, weren't getting any permanent disability benefits because there was no negligence there. And families were struggling greatly because of that. On the other side, when you did have negligence there and someone got injured, you had some of the upstart businesses that were basically getting hit very hard financially, and you had some employers going out of business because of that, which affected the entire workforce for that business. And so both sides kind of come together and they developed the workers' compensation process. And essentially what they did is they covered many more injuries than was covered under the negligence-based system. They covered many more injured workers, but they limited the amount that can be recovered. You don't get pain and suffering, for instance, in a workers' compensation claim, which we've talked about before. We've talked about the benefits that you can receive in workers' comp: medical, lost wage, permanent disability, vocational rehabilitation. From there, so that's where what kind of developed the system. And what they did is say, we're not going to, the injured worker doesn't have to prove negligence. They have to prove that the injury occurred while they were during the course and scope of their employment. And if they can prove that and it's a work-related injury, then they get these benefits, but they're not going to get as much in benefit. So you expanded greatly the number of people who could recover benefits. You protected a lot more families that way by doing that, but you weren't getting verdicts or jury awards that were putting companies out of business. Now, obviously, workers' comp insurance carriers and all of those are around as well now, and so that is part of that process. And that's the reason that is. That's the reason if an injured worker is just merely negligent in causing their own injury, it does not affect their entitlement to receive benefits. If if there's a wet floor sign up, they see the wet floor sign and they walk across it and slip and fall. If it's on the job, then they're still entitled to benefits, even though they were warned that the floor was wet and they slipped and fell.
Because I mean that's still a normal part of their work activity. They're basically, hey, this is what I do for my job. I've got to walk from point A to point B. Maybe I'm carrying something, maybe I'm not. Yeah, all of that makes sense. I mean, this is a normal part of their work, and they were hurt in
carrying out their
while
job.
they were doing it.
Exactly.
Yeah.
And that's the reason that the law is the way it is from that standpoint. Now,
if I could real quick, you keep saying without proving negligence. Let me give another example. So jumping out of workers' comp into personal injury, a car wreck, you have to prove negligence, right?
Correct.
So that's a little bit different. None of those bills get paid up front. All of that waits until the end. If you can prove that the other driver was at fault, they were negligent, then you have a recovery. Workers' comp doesn't work like that. You get benefits from the outset.
correct, except for the limited benefit under Kentucky motor vehicle law that has the PIP coverage that we've talked about before, which will pay up to, depending on what your limits are, but a minimum of $10,000 for medical or lost wages. That's paid by the vehicle you're in. As opposed to the at-fault vehicle. Now, the at-fault vehicle's insurance will reimburse all the other ones at a later time from that. So there is avenues to get some medical in a car wreck setting under that right off the bat. But any other negligence base, you slip and fall at a grocery store,
Walmart.
Yeah, a medical negligence claim, nursing home negligence. Nobody pays the medical bills except potentially health insurance that can get reimbursed later on. But the at-fault party doesn't pay until the claim is completely resolved.
That makes sense. And we've talked about premises liability in the past.
Correct.
And then just, as you're talking about car wrecks, as we were talking about car wrecks right now, and PIP applies, obviously, although there is that motorcycle exclusion that, again, friends, if you want to go back to the podcast and look for several of Jeff's episodes on motorcycle accidents, you'll see why that's something you need to know about as well. But
Yes.
That being said, let's circle back all the way back to workers' comp. Jeff, we were just talking about, okay, negligence doesn't really apply. You're doing things in the normal course of your job. You're hurt while you're doing that. So, again, you have the right and you have the access to the benefits.
Correct. You have the right and access to benefits if negligence is what's at play. But there are some actions by the injured worker that can affect their ability to be able to pursue a claim at all successfully or reduce the amount that they could recover. As far as the reduction, if the injured worker violates an OSHA statute or regulation or an employer safety rule, and that causes their injury, then their benefits are reduced by 15% for that violation of the safety statute or safety rule of the employer. So if you've got, an employer that requires you to wear a harness when you're working, OSHA requires it as well, but it requires you to wear a harness when you're up working at a high rate, altitude, and there's no rails or anything around, roofers and things of that nature, for instance, and they require the harness, they provide the harness, and they enforce that rule. All of these have to apply, and they enforce that rule, and you get up on the roof and you don't have the harness on and you fall off of that roof and you're injured, you still are entitled to workers' compensation benefits, but what you recover is going to be reduced by 15% because you violated that safety rule that led to your injury. Now, the safety rule has to apply to the injury, or the employer rule has to apply to the injury. So you'll see, and we've talked about this before fairly recently, I believe. I can't remember what podcast episode, but where you have to give notice as soon as practical. Some employers say, well, you've got to give notice within 24 hours of the injury occurring, and I've had some employers tell the injured workers, well, you didn't give notice until 2 days afterwards, so your injury is no longer covered by workers' comp. No, that's not the law. That's not a safety rule that had anything to do with the injury happening, and so that doesn't reduce what you recover in the workers' compensation claim from that standpoint. So you have that situation, and it's vice versa if the employer commits an OSHA violation. In other words, you're supposed to be up on the roof and you're supposed to have the harnesses and be tied off, and they don't provide you the harnesses. They don't enforce that OSHA rule, and they tell you to get up on that roof even though you don't have a harness on, and you fall off of the roof. You're not hit at that point in time because the employer didn't provide you the safety appliances. They violated OSHA rule, and your benefits actually will increase because of their violation. And actually, because they want employers complying with OSHA rules, the benefits are increased by 30%. Yours are decreased by 15. If the employer violates, your benefits are increased by 30%. So because they want to make sure the employers are incentivized to follow OSHA, not just by the OSHA citations that they have to pay, but also by other means.
They want it to sting a little bit to try to keep the workers safe.
Exactly,
Yeah.
and frankly, compliance with OSHA begins first with the employer.
Yeah.
In my opinion,
Yeah.
I mean the employees, frankly, usually are. I mean, I guess they could go find the lanyards and the harnesses and purchase those online, but it's much easier for the employer to do that and to provide that for the injured workers, and they want to make sure they are enforcing those safety regulations as safety standards.
Yeah, when you talk about some of the things that an employer could do, I mean, you do a lot of work up in Bowling Green at some of the auto manufacturing facilities around, and
Yes.
If the conveyor system is going a little bit faster than it's rated to go for, if somebody has a press or a stamping machine and the safety guards were not installed, all those kind of things that maybe somebody else is responsible for, even though you're the one operating the press, somebody violated probably an OSHA standard here, I would think.
Correct. Yeah. I've unfortunately represented folks who they've taken the safety devices off of the machines. A press that has the in fact, I operated a press when I was going to Murray State, and I worked at Brick and Stratton here in Murray, and I operated presses, and it required both hands. I had to push buttons with both hands for the press to operate, and also had a harness around my hands that were on a cable that when that press come down, if my hands were up there, it would jerk my hands back. So it was a double redundancy, so to speak, from a safety standpoint there. But I have represented clients where those type of safety devices that are built into the machines have been bypassed by the employer intentionally, or they've taken the guard off of a saw, and the worker get injured because of that. And those type of violations are where the 30% safety penalty comes in. Frankly, in my opinion, when they start doing those type of things, they ought to be able to go outside of workers' compensation. But unfortunately, in Kentucky, even when the employer intentionally violates an OSHA regulation, a safety statute, or even dismantles a safety device on the machine, your exclusive remedy is still your workers' compensation benefits.
That makes sense. So, there are, however, some situations where, again, if you're goofing off, if you're engaged in what is typically called horseplay, that could put you at risk of losing out on some of these benefits,
Yes.
right?
If you're engaged in horseplay, then that can cause you to lose benefits from that standpoint. But that's going to apply to the ones engaging in horseplay. So if you've got two coworkers engaging in horseplay, you're not, but you get injured because of their horseplay, you still get the workers' compensation benefits. But if one of the ones engaging in horseplay is the one injured, then they are potentially causing themselves to lose benefits under the Workers' Compensation Act. Also, if the injury is a result of your intent, if you have a willful intent to injure yourself or to kill yourself on the job, unfortunately, that has occurred at a time or two where someone has committed or attempted to commit suicide while they were at work. Those type of things are not covered under workers' comp. That's the statute's clear. If it's an intent to injure yourself is what caused your injury or your death, then that's not covered under workers' compensation. That was your own doing, so to speak, if that is your intent. Now, proving an employee's intent can be very difficult in those settings, but if that is, if you've got evidence that it was an intentional act on the injured worker's behalf, then they're not going to be entitled to workers' compensation benefits.
That makes sense. One of the things that's coming up now, and I think we have briefly touched on this in a previous episode with Kentucky getting ready to implement medical marijuana in here. You start thinking about things like, well, what if an employee shows up intoxicated at the workplace? That might be alcohol, that might be a substance, that could even be a prescription drug that maybe they're taking under doctor's orders or maybe outside of doctor's orders. If they've done something to intoxicate themselves and then they get injured, I would think that would have a negative impact on their right to benefits.
Certainly, it can result in a complete bar of the claim. Now, the statute used to be if it was because of your intentional or willful intoxication. So, if you had a situation where somebody slipped something in your drink and you didn't know it, and you got injured because of that, that didn't affect your entitlement to workers' compensation benefits because it wasn't willful. From there, they changed the law around to where in 2018 they changed the law, and they did not. The way they worded it, I think there's a real serious question on whether being drunk from alcohol or intoxicated from alcohol on the job would preclude you from receiving workers' compensation benefits. Now, I'm not telling anybody to go out and have several drinks and then go to work from that standpoint, but it's weird because they took out it was willful intoxication. So whatever caused you to be intoxicated, and they went to a specific language, and it's hard to kind of summarize it. So I'm just going to read it off. I normally don't read off language because it can be extremely boring. But the way they changed the wording of it is if the employee voluntarily introduced an illegal, non-prescribed substance or substances, or a prescribed substance or substances in an amount in excess of the prescribed amounts into his or her body, detected in the blood as measured by a scientifically reliable test that could cause a disturbance of the mental or physical capacities, it shall be presumed that the illegal, non-prescribed substance or substances or the prescribed substances in an excessive amount is the cause of the injury, occupational disease, or death, and there should be no liability for compensation if that is the case. And so, alcohol is not an illegal substance if you're over 21 years of age. And so and it's not a prescribed substance. So it's frankly doesn't come, this statute I don't think affects that. There's not been a court case that's addressed the issue that I'm aware of. The Court of Appeals Supreme Court has not addressed that issue. I think there's been some administrative law judges' opinions that agreed with my reading of the statute from there. And when this was come about, it leaves a lot of questions on how things are going to be worded because I mean, in my opinion, this creates an irrebuttable presumption. Used to, you had the injured worker, the employer had to prove intoxication. And I had several cases where the employer tried to prove that through urine drug screens where my client had marijuana in a urine drug screen or even other substances in a urine drug screen after the injury occurred. But, substances stay in the urine much longer than they stay in the blood, and a substance in your urine does not intoxicate you. It actually shows that it's out of your system at that point and cannot intoxicate you. And I've had expert witnesses that I've used in those cases to establish that, no, that's not intoxicating at that point. The intoxicating effects have been over for a long time for it to be into the urine. And I was successful. Usually in those cases, what we do is we also not only have the expert, but talk to coworkers and see if they were showing signs of intoxication when they were at work, and if they were not, then, and frankly, I don't recall any of those cases that I lost. If they were showing signs of intoxication, then they, the employer is probably going to win in that situation, because that's what they were looking for, not just what was in there. Now, the new statute talks about it being in the blood, so they have to actually establish that it is in the blood. Now, the question is, how do you establish that? I think you have to have, in my opinion, a blood test. That's unclear at this point, because breathalyzer, even though alcohol is, I don't think is covered here, breathalyzer talks about how much alcohol is in the bloodstream through the breathalyzer. So arguably, you can say that test would establish alcohol in the bloodstream. But I don't know of any other test that would test for other substances in the bloodstream. There may be some that I'm just not familiar with, but they have to establish that it's in the bloodstream, which is where it's going to be if it's providing any type of intoxicating effect. But they don't have to establish intoxication by it anymore. So if you have a very, very small, minute amount of marijuana at this point, because marijuana is technically still not legal in Kentucky. I can't remember when the medical marijuana kicks in. I think it's 2026 or maybe later this year. I can't remember exactly when it kicks in, but whenever that kicks in, then that would change. But right now, marijuana is an illegal substance. So if you have a small amount that every doctor, every toxicologist, every scientist says that small amount would not be intoxicating. It is so small, it would no longer be intoxicating. Doesn't matter. If it's in the system, it is presumed that is the cause of the person's injury or occupational disease or death. And I think there's a serious question on, frankly, in my opinion, on whether this would be constitutional. In some regards, it hadn't been challenged there. But as I read this, in the coal industry, coal workers frequently contract what's commonly referred to as black lung or coal workers' pneumoconiosis. And the way this statute is written, because it's very poorly written, but if that person, if you had a coal worker who had a major headache and was really hurting, and they took their wife's Loratab prescription, and they took one of those the night before, and then they go to the doctor for having coworkers' pneumoconiosis or black lung, and they do a blood test on them, and there's Loratab in their system. Well, every doctor will tell you Loratab doesn't cause black lung or pneumoconiosis, but by the way this statute's written, it's presumed the Loratab caused the black lung, and I think that's just completely ridiculous the way it's worded, but that is the way it's worded at this point in time.
Wow. Well, and that's as of the 2018 ruling. I mean, is that roughly when all this came into play?
28 July. This statute become effective July 14, 2018, and insurance companies are they are smart in some regards. They make some dumb decisions at times, but a lot of times they will listen to their attorneys on challenging some issues. They may challenge it initially, but then the attorney say, look, you really don't want an appellate court making the decision in this case because it not only affects this case, but it's going to affect all these other cases, and if this statute's held unconstitutional, then if the legitimate times when the person is intoxicated, you're going to lose all of those, and the court's going to, or the legislature's going to have to pass a new statute, so it's better not to do that. It wasn't my case, but an attorney called me up to ask me my thoughts and how they should proceed on a case that was a situation that was going to be a very good one to challenge the constitutionality of it if the insurance company continued on with arguing the intoxication defense. And his client was working outside. I can't remember exactly what the gentleman was doing, but he was working outside very close to a road, but he had his back to the road. I don't think he was weed eating, but I'm not sure what he was doing. But he had his back to the road, had hearing protection on, and a truck driver was backing up down the road to back into the property of the employer, cut the corner too quickly, and hit this worker, causing severe injuries, serious injuries to the guy. And when they went to the hospital, took his blood, marijuana was in his blood. They got video of the accident, absolutely no, and he said he's seen the video because they had video surveillance outside. He's watched the video. His guy just sitting there doing his job, has no idea the truck's even coming. And he gets hit. Said, the truck driver's 100% at fault in causing this. The insurance company was arguing he had marijuana in his system, so this is presumed to be the cause of the accident. I have never seen that go up on appeal. I look at all the workers' comp board decisions, court of appeals, and Supreme Court decisions on workers' compensation matters. I keep up to date on every one of those decisions, and it has not been appealed. My expectation is that when he filed it and the defense attorney got involved, they told the insurance company, this is not one you want to fight because this could cause the whole statute to be held unconstitutional in this situation, because this was just an egregious miscarriage of justice if they were to take that position. And so, but that's the way this statute, it is so clumsily worded that it can cause a significant miscarriage of justice if the insurance company tries to follow it to the full extent of that. It causes a miscarriage of the way because, frankly, if you are drunk on the job from alcohol and you cause your own injury, in my opinion, you shouldn't be getting benefits for it, but now you do. It doesn't make any sense.
As we've said many, many times in these episodes, the law is complicated, and you really need to hire an experienced attorney who can help kind of assess what happened based on the facts, and who can gather up the evidence and then get the right experts, if medical experts or whomever's required. I mean, that's with over 30 years of experience. I mean, that's what you bring to the table. I mean, you've got the ability, you've got the connections, you kind of know how to put these cases together, obviously. And it's one of those things, depending on the circumstances, you can't just say, yeah, you're either at fault and you're not going to get benefits, or you're at fault and you are going to get benefits. It depends on the situation. And that's kind of what makes this, again, just so complicated.
Yeah, it can be very, very complicated. And, I mentioned a while ago, I keep up with all these appellate court opinions. The reason I do that is, especially with workers' compensation, you've got the statutes, but the way the courts interpret those statutes make a huge difference. So like on whether it has to be a blood test that's done or another type of test can be used. Well, if I'm taking the position that it's got to be a blood test and there's a court of appeals decision that becomes final that says, no, it can be a urine test, if a doctor says, well, I can extrapolate back. I think that doctor is going to have a hard time justifying that. But if they say I can extrapolate back and show that this is what's in the bloodstream at the time that this urine test was done, then that would satisfy the criteria under the statute. And I don't know that. Then I'm not representing my client to the best of my ability from that. And in fact, the client's going to be I advance costs, but they're not going to realize, they're not going to know, I'm going to be sitting here thinking, they don't have blood tests, so you're in great shape. And then I don't know what the law is, and my client gets hammered at the end because I didn't know what the law is. And so that's the reason I keep up to date with, and I'm not saying I don't know what the law is. That's what's going to happen if you don't keep up to date with those things. That's the reason I read every workers' comp board opinion, every court of appeals opinion, and every Supreme Court opinion on workers' comp, usually within a week of it being rendered.
And Jeff, that's why I never ask what you're doing on the weekend. But no, I mean, but to be good at what you do, and you are, if you go out and look at the Google reviews that you've amassed over 30-something years, I mean, there's so many positive comments and 5-star reviews. It's because you take the time to go one step further. Hey, this isn't about the case I'm representing right now, but it could affect other cases in the future. And you're committed enough to actually go out there and do that. And that's, I think, why a lot of your colleagues call you about comp cases. I think that's why other organizations have brought you in to speak about Kentucky workers' comp claim. And I think that's why you've got the track record that you actually have up at the Kentucky Supreme Court, which we've talked about many times on the podcast, is you put the work in. And that's fantastic.
Well, I appreciate that. And I hope every attorney who does this type of practice puts that work in, because that's what you have to do to represent your clients to the best of your ability. And that's what every attorney ought to be doing, is representing their clients to the best of their ability.
Makes a lot of sense here. Jeff, I want to thank you for your time. But before we go, you've got 2 different offices here in Kentucky. But one phone number. Do you kind of want to talk about the 2 offices that you have?
Sure.
And the best way for somebody to get in touch with you?
Sure. I have the office here in Murray, Kentucky, in Calloway County, where I've been at for 32 years. And I do have now an office in Hopkinsville. It's been open for a little over a year now, where I meet with clients up there. That office is by appointment. And I think it's just better to have one phone number for a couple of reasons. But the least of, or the most important, is that when you call me, I want a live person answering the phone. And so the phone number to reach out if you have any questions over workers' comp or any personal injury matter is 270-753-0053. If you live close to Murray or Calloway County, you can see me in my Murray office. If you live in Christian County or up in that area and want to meet me in my Hopkinsville office, we'll set up the appointment there. If you live further away, I meet clients in Bowling Green at times, in Louisville at times, but we can do phone appointments. I can do video appointments as well. So, and I represent clients all over the state. From that standpoint, we try to make it as easy as we can for our clients, because that's who we do this for.
Jeff, outstanding. Buddy, I hope you have a great week, and look forward to getting back here and talking to you in a couple more weeks.
Thank you, Jim.
Take care, guy. Bye-bye.
Bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.